So maybe one of the sergeants can show him to the back microphone. Can you turn on the back microphone? Okay. That's okay. Don't worry about it.
Thank you, Chairman. And thank you, council members.
Can we turn that mic on, please?
Hello? Okay. Thank you, Chairman, and thank you, members of the board. Pretty much everything has been said here today. The thing I would like to say most importantly is that we actually need to work on industrializing and creating an industrial plan for marijuana, the industry itself. Just everything we're doing and everything that everyone's trying to do with the legalization and trying to deal with the money issues. Yes, you know, the main issue for the money and financial issues is changing it from a Schedule I drug to a Schedule II, but doing that is fine and dandy, but what are you going to do with the system that's limp, questionable, and has no control and no industrialization plan for a set layout of how to control the industry?
Thank you.
Thank you.
Okay. With that, Mr. Heckers.
Chair and members of the committee, thank you for the opportunity to provide testimony in regards to Umpqua Bank's position on banking marijuana-related businesses. My name is Kurt Heckers. I'm the Senior Vice President and Bank Secrecy Act Officer with Umpqua Bank. I'm charged with the responsibility of constructing a AML compliance program that is commensurate with the bank's risk profile. Umpqua Bank is a $23 billion financial institution serving 5 western states with upwards of 330 banking offices throughout our footprint, which includes Oregon, Washington, California, Nevada, and Idaho. Umpqua currently provides banking services in states that have legalized recreational and medicinal marijuana. As a result, Umpqua is uniquely positioned to comment on the challenges when state law and federal law collide, as it does on the marijuana issue, with both Oregon and Washington having legalized recreational and medicinal marijuana. Umpqua Bank is required to comply with federal law in its business operations because it is regulated like all financial institutions at the federal level. At the federal level, marijuana is listed as a Schedule I drug on the Controlled Substances Act. The growing of, possession of, or sale of marijuana is a felony. The Bank Secrecy Act of 1970, as amended, requires U.S. financial institutions to assist U.S. government agencies to detect and prevent money laundering. Specifically, the Act requires financial institutions to keep records of cash purchases, file reports of cash transactions exceeding $10,000, and to report suspicious activity that might signify money laundering, tax evasion, or other criminal activities. In 2013, as referenced earlier, then Deputy Attorney General James M. Cole issued a memorandum, basically noted as the Cole Memo, for all United States attorneys titled Guidance Regarding Marijuana-Related Financial Crimes. Within this memo, the U.S. Justice Department reiterated previous guidance concerning marijuana enforcement under the Controlled Substances Act and reiterated the Justice Department's commitment to enforcing the CSA consistent with Congress's determination that marijuana is a dangerous drug that serves a significant source of revenue to large-scale criminal enterprises, gangs, and cartels. The guidance instructed Department of Justice attorneys and law enforcement to focus on 8 priorities in enforcing the CSA against marijuana-related businesses. Key portions of that guidance were: 1, preventing the distribution of marijuana to minors, preventing revenue from the sale of marijuana from going to criminal enterprises, gangs, and cartels; 3, preventing the diversion of marijuana from states where it is legal under state law in some form to other states, and preventing state-authorized marijuana activity from being used as a cover or pretext for the trafficking of other illegal drugs or other illegal activity. That memorandum further touches on the fact that the provisions of the money laundering statutes, the unlicensed remitter statutes, and the Bank Secrecy Act remain in effect with respect to marijuana-related conduct. As such, financial transactions involving proceeds generated by marijuana-related conduct can form the basis for prosecution under the money laundering statutes. In addition, financial institutions that conduct transactions with money generated by marijuana-related conduct could face criminal liability under the BSA for, among other things, failing to identify or report financial transactions that involve the proceeds of marijuana-related violations of the Controlled Substances Act. As also referenced earlier, in February of 2014, the Financial Crimes Enforcement Network, aka FinCEN, issued guidance to financial institutions on marijuana businesses, titled, the Fin guidance was 2015-G001, BSA expectations regarding marijuana-related businesses. Within this guidance, FinCEN reinforces the fact that the Controlled Substances Act makes it illegal under federal law to manufacture, distribute, or dispense marijuana. While this guidance clarifies how financial institutions can provide services to marijuana-related businesses consistent with their BSA obligations, it outlines that financial institutions must weigh the risks associated with offering services with their capacity to manage those risks effectively. The guidance essentially requires financial institutions to perform due diligence that includes verifying appropriate state licensing, developing an understanding of the expected business activity, ongoing monitoring of publicly available information, and lastly, whether or not the MRB implicates one of the Cole Memo priorities or violates state law. The validation that the MRB does or does not comply with the Cole Memo priorities is potentially one of the toughest challenges for banks. There is virtually no guaranteed way that a bank can perform enough due diligence to ensure that the MRB is not or has not violated the Cole Memo law enforcement priorities, particularly as it applies to preventing revenue from the sale of marijuana from going to criminal enterprises, gangs, and cartels, or preventing diversion of marijuana from states where it is legal to states where it is not legal. In fact, there have been ongoing concerns by law enforcement of cartel infiltration into state legalized marijuana businesses. And according to a recent news story, 20 drug traffickers were accused of relocating to Colorado to grow marijuana that was then sent to Florida. In the same news report, the owner of a skydiving business crammed hundreds of pounds of Colorado marijuana into his plane, flew the marijuana to Minnesota, where associates allegedly sold it for millions of dollars in cash. While there has not been, as of yet, a direct tie to a state-licensed facility for these cases, the risk is still present. So while a bank may perform a good faith effort in ensuring an MRB is complying with the Cole Memo, there is no ironclad way for a bank to ensure 100% compliance with the Cole Memo. Should a state-licensed MRB be charged by federal law enforcement in regards to a CSA Schedule I offense, such as sending marijuana out of state where it is not legal in order to earn significantly more profit for the product, the bank that is providing financial services to the MRB could be charged under the BSA for money laundering.
Can I just get closing remarks on this, please?
Sure. Recent attempts that update statutes to allow for banks to provide financial services for MRBs without facing possible criminal state penalties in no way affords banks any protection from a federal perspective. Stakeholders should focus on federal instead of state solutions. Ultimately, Congress needs to act and either decriminalize marijuana or remove it in its entirety from the CSA in order for financial institutions to be able to take the risk of banking these business entities. In conclusion, based upon the risks outlined above, most financial institutions have determined that the reputational, legal, regulatory, and strategic risks far outweigh any potential benefit of providing services to state-sanctioned marijuana-related businesses. Thank you for the opportunity to testify on this very challenging issue. I hope this perspective is helpful in understanding the complex issues faced by financial institutions and navigating an environment where state laws are at odds with federal law.
Mr. Heggers, thank you for your testimony today. The next two speakers, Ms. Sanchez and Ms. Wellborn, you're both representing the Community Credit Union of Southern Humboldt. You can either split your time or will you be speaking just individual, just one speaker?
Go ahead. Hi, my name is Janet Sanchez. I'm Senior Vice President at Community Credit Union of Southern Humboldt. Chairman Donadna, you have hit in your opening comments spot on a good summary of why it's so difficult for the financial industry to bank this money. So you have taken my primary points right off the page. I just want to flesh those out for you and give you some boots on the ground perspective of what you already know.
Thank you, and you can speak for as long as you want.
The obstacles for banking cannabis money are so incredibly varied. They touch every single aspect of a financial institution. We are charged with safeguarding our depositors' funds. So we live in the world of risk assessment and risk mitigation. We understand that very well. So why is it so risky for us to take this cannabis money? Well, there's the first obvious one of regulatory compliance risk. It's illegal. That puts us on the wrong side of regulatory compliance right out of the gate. The Cole memos were, of course, intended to mitigate that risk, but they are so nebulous that there simply isn't any way for us to know for certain that we are following them. And that's been made very clear by several speakers here today. Those 8 law enforcement priorities that are listed, they are something that the financial institutions, it's out of their purview to do those. You know, we bank businesses that deal with highly regulated products, grocery stores that sell tobacco, bars that serve liquor, gun dealers that sell deadly weapons, and pharmacies that distribute controlled substances. And I've had plenty of conversations with NCUA examiners and IRS investigators, but not once has an NCUA examiner ever asked me if I've investigated the policies and procedures and processes of the bar across the street to make sure that they're not getting alcohol into the hands of minors. Not once has an IRS investigator ever asked me if I've examined the documentation of a gun dealership to make sure that they are getting the appropriate background checks and following the appropriate waiting periods before handing out their product. That's not what we do, but that's what the Cole memos are requiring that we do. Now, that doesn't mean that nobody's doing this in these industries. It just means that the financial institution is not the proper body to do it. There is a very broad spectrum of interpretation of the Cole memos, from really conservative to simply, we don't really have to do anything, we just report it if it's done. However, you can see from the lack of participation from financial industries that we take, on the whole, a very conservative approach to this because of the risk that's involved with it. Even if we have extremely robust state banking laws, the financial industry is not going to walk through that door, because the Cole memo says very clearly, and I'm quoting from the Cole memo, that the guidance herein, nor any state or local law, provides a legal defense to a violation of federal law, including any civil or criminal violation of the CSA. So robust state laws are not going to be very helpful for us in this topic. So we have this regulatory risk, and then once you get into being out of compliance with the regulatory risk, then you're risking punitive damages and lots of other charges against you. Now, punitive damages are a very real threat. We live in an environment right now where the regulatory bodies and government agencies are relying more and more on punitive damages to make their budgets. And that is a great motivator for them to pass out these damages. And these damages are punitive. They're meant to hurt. They're big. Again, a very big risk that you're asking financial institutions to take. So the regulatory risk, the compliance risk, the financial risk of the punitive damages, and then the reputation risk. Once it hits the headlines that we're out of compliance with federal law and we have punitive damages because of it, or we're under investigation, our reputation is gone. And because we have a fiduciary responsibility with our depositors, once that trust is gone, we may as well just shutter the doors and go home. We are out of business. There's one final point I want to make, and that's balance sheet risk that I haven't really heard anybody else deal with. When you open that door, well, I did hear it referred to once. When you open that door and allow in those deposits, we can't just be a big vault for the cannabis industry. We have ratios, we have balance sheets and income statements that we have to maintain. If we just pull all those deposits in, our balance sheet's going to be way out of balance because those deposits don't belong to us. They are liabilities on our balance sheet. We have to make that money work for us somehow. And if we don't, our ratios are all out of whack. And then Commissioner Owen's staff is here to tell us that we have to correct this. And, you know, there are ways that we can correct it, but it involves things that, again, cause serious compliance issues for us. And I'm not going to get into that. Mr. Pearson, I believe, is going to touch on that aspect. So regulatory compliance risk, financial risk from those punitive damages, reputation risk when word gets out that we're out of compliance. And then that balance sheet risk, and I need you to really notice something, and you've heard this over and over today, all of these risks are stemming from the federal level, all of them. I don't see a statewide solution. I really think the pressure needs to be moving to the West Coast, to Washington, D.C., to get these things resolved. It has to go up the chain.
Okay. Thank you so much for that, Ms. Sanchez. I'd like to also welcome my colleague and member of this committee, Sebastian Ridley Thomas. Thank you for being here. Ms. Wellborn, would you like to add any comments to what Ms. Sanchez said briefly?
It's hard to follow Janet in any situation. My name is Sean Wellborn. I'm the CEO of Community Credit Union, and we live in a very, very small community that is, we're so remote we're actually considered frontier. Cash is our community's business. All of the businesses are fundamentally paid in cash. It's our responsibility to serve as the local community financial institution, and it makes it incredibly difficult when we are being inundated with more and more rules and regulations. Unlike one of the prior speakers, I don't see any way that we have the magic wand that turns cash into an ACH product, given that it's governed under Regulation E, which is a federal reg. So I appreciate everything that Janet has shared with us, and I thank you very much for letting us have some of your time.
Thank you so much. We will now move to Mr. Pearson. If you could keep your comments to 4 minutes, and then
I will, Mr. Chairman. I'm an attorney, and I'll be briefer than that.
Thank you.
I would like to touch on a couple of issues that I don't think have been addressed yet today. I think we've covered the deposit side and the CSA and the federal law, Cole memos very, very well through a number of speakers. I'd like to speak to the loan side. Many banks and credit unions are asked every day to make commercial loans of small and large size to their community borrowers. They have challenges on the loan side from federal law as well. It's known as the RICO law, the Racketeering, Influence, Corrupt Organizations Law. There was an article in the Wall Street Journal just a few weeks back that suggested that you are more likely to have your personal property assets seized by some wing of the government than stolen by a criminal these days, because asset seizures are that prevalent in most states. The standard under RICO for the federal authorities to seize an asset is a suspicion that a crime has been committed under the CSA or a number of other laws. A suspicion that a crime has been committed. The burden then shifts to the owner of that asset, or in the case of a bank or a credit union, the lien holder on that asset, to prove a negative. And that is essentially that they did not know and had no reason to know that the asset had been used in a criminal enterprise or was derived from proceeds used in a criminal enterprise. That places banks and credit unions in a very difficult position if they lend to anything in the vicinity of the cannabis industry. Their concern over assets being seized is very real. It has happened in Arizona and some other states at this point. And besides the CSA and amendments we need in that area, we certainly need RICO addressed as well to provide some level of safe harbor to banks and credit unions who aren't into the business of judging how an asset's being used necessarily when they make a loan on the collateral. A couple of other minor points I'd like to hit as well. We've had several speakers comment relative to the deception that their businesses have had to engage in to open deposit side banking and credit union accounts. that deception leads to a chain reaction inside the bank or credit union as well. I have read many examination reports from federal and state examiners that essentially suggest that the failure to further research, is that really a legitimate car wash? Is that really a legitimate movie business that deals in cash? The failure to further research that is a mistake by the bank or the credit union itself. And if they'd done a little bit of digging, they would have discovered that it was a front for a cannabis industry business. In turn, those banks and credit unions have been criticized in regulatory documents for not filing suspicious activity reports due to that deception. So it's not as simple as, wow, we got faked out as an industry and the business was something other than what we were told. There are ramifications inside the doors for those officers as well for not having filed those SARs. My last comment, and in closing, I think as we move from a medical marijuana permissive state to a rec permissive state, there will be a tendency to want to regulate the banking into the industry very, very heavily. And for all the reasons that Mr. Ruckers and Ms. Sanchez have noted, the banking industry, even with legal rec and legal medical marijuana use, will still shy away from serving the industry if it's over-regulated. If they're expected to go in and figure out what a business is actually doing on a day-to-day basis, monitor it on an ongoing basis, and file multiple levels of reporting to the federal government, perhaps the state government, they still will choose not to do business with that industry. As one of our speakers said, banking is a privilege. It's not a right. And the banks and the credit unions will elect not to do business with those businesses if we overregulate it. Thank you, Mr. Chairman.
I had a couple questions. You answered most of them. I will see if my colleague from Los Angeles has any questions.
Yes, to the speakers on this panel, given the challenges in banking this emerging industry, is it possible that you might suggest that the state take on a role similar to what we do with the state fund as providers of last resort, a state-chartered nonprofit or a financial services institution that would provide a bridge as this industry continues to mature?
Well, a state-run institution would be subject to the same rules, regulations that a non-state chartered or non-state implemented bank would be. So you have to comply with the Bank Secrecy Act, file suspicious activity reports, due diligence, the entire piece, as well as have access to the Federal Reserve, which clearly has been shown to be problematic.
Thank you.
That's all. Thank you, Mr. Chairman.
Thank you. With that, we're going to move to public comment. We also will ask, is Sam Umid here? Sam, if you want to come up, he's an owner and advocate from the San Fernando Valley. And also Don Duncan. He's a California director for Americans for Access. They're going to give each about 90 seconds to 2 minutes. They can come sit at the table, and then we'll open up to general comment after that. And also, if we have anyone from Fiona Ma's office from the BOE, if they'd like to come up as well, you feel free to come up.
Don Duncan had to leave to pick up his child from school.
Okay.
Unfortunately.
That's okay. Go ahead if you want to introduce yourself, and if you can keep it to 2 minutes.
Sure. My name is Sam Humid. I am the founder of Perennial Holistic Wellness Center, one of Los Angeles' first medical marijuana dispensaries regulated under Proposition D. I have also been fortunate enough to be one of the dispensaries that has been able to have a bank account since day one in 2006. For whatever reason, I don't know, but I've always had a bank account with various big transactional banks. Because of the bank records that I have and been able to provide to the BOE, I've been subject to a number of BOE audits. But with those records, I've been able to show the BOE that these are actually my revenues, these are the taxes that are due, and this is what needs to happen. There's complete transparency there because of my banking. On the flip side of that, as a victim of somebody who was robbed at my dispensary, I was very grateful for the fact that I had credit card processing and a bank account where all of my cash and all of my assets were stored. So during the robbery, there was nothing to take. There was no cash on site. There was no vault full of hundreds of thousands of dollars in cash. Everything was already taken care of. I was able to write checks to all my vendors and the BOE and so on and so forth. However, I do consult to many other dispensaries, and they are not nearly as fortunate as I am. They have to, again, store large amounts of cash in various locations around the city and the state in order to prep themselves for various tax payments that are due and start buying money orders in advance for the hundreds and thousands of dollars at a time to bring in stacks of money orders to the BOE because they can't bring in cash or they fear to bring in cash. And we all know it's going to take a long time for the feds to come up with a solution, and I really implore that you guys do the due diligence necessary to make sure that something is available, not only just for the state's tax benefit, but also for public safety.
I guess my only question to you, you're someone that's been in this business a long time, you own dispensaries, you've been an advocate. Is there anything you heard in the testimony today from any of the panels that you'd either want to clarify or anything you'd want to, as someone that's actually dealt with having, it seems like you've obviously been very lucky, and I won't put you on the spot to ask you how you've had a bank account. We don't want to, we don't have the time for that, but is there anything you heard today in terms of the challenges facing dispensary owners under the new framework that we've created as a state that you'd want to reiterate or touch on?
Right. I mean, granted, I was fortunate enough, but I was also in the fear every day that my accounts would get audited by whoever at the banking system, and I would lose my bank accounts and have to be in the same situation as everybody else. Again, it comes down to changing the Controlled Substances Act. It requires the state of California and all of the legislators here to come in force to request that the United States change this rule immediately.
Mr. Humidid, thank you for coming up today. Thank you for giving your perspective from a local point of view, and we appreciate it and look forward to working with you in the future. If Mr. Moreland is still here from the DOE, member Guatemala's office, please come up. Mr. Moreland, thank you.
Thank you, Mr. Chair. Thank you, members of this committee. This is a very important subject to us. I represent Chairwoman Fiona Ma from the Board of Equalization. I'm her legislative director. District 2, which is the district we represent, in my opinion, is at the forefront of this policy problem. We've collected, in 2015, we collected $5 million in cash payments. The BOE has collected about $44 million in tax revenue. I would assume most of that is in cash. I've heard estimates that there are about 70% of the industry is unbanked. So you can just extract those numbers from that. As you may know, we've held a variety of stakeholder meetings. We met with a variety of stakeholders outside of that meeting. We've worked on various legislation. Last year, we worked with Dr. Wood on his state chartered credit union within the BOE. It was a great discussion point. It got things started. And we also sponsored AJR 25 by Assemblymember Lackey. Excuse me. So we're very active in this issue. It's a problem for us. It's a problem for the BOE. We also realize that it is an issue for other state agencies because they are going to be collecting more cash. And so we're here to answer any questions. We're here to work with you and do whatever we can. So thank you.
Mr. Moreland, please thank new Chairwoman Ma and her work in this area. We appreciate her diligence and we look forward to working with her in the future. And thank you for your testimony today.
Thank you.
Do we have any other public comment? I know we have Mr. Crabtree who will welcome up here to speak from the table as well. But if there's any other public comment, if they want to line up by the back microphone as well. But if Mr. Crabtree is still here, feel free to come up. And if you'll please introduce yourself and your title.
I'd just like to start by thanking the chairman and the committee for giving me the time to speak. My name is Adam Crabtree, and I'm the CEO of Nationwide Compliance Specialists. I'd like to start by saying we're not a kiosk, we're not a point of sale, we're not a cryptocurrency, and we're not a Band-Aid. We are an advanced analytics company focused on applying our patent-pending predictive algorithm to the cannabis industry. Our mission is to align the interests of the three main stakeholders: government and regulatory agencies, the financial industry, and legitimate cannabis-based businesses. To the government and regulatory agencies, we offer increased tax revenue, public safety, and reliable information. To the financial industry, we offer decreased risk and compliance costs. And to the legitimate cannabis-based businesses, we offer the opportunity to have normalized front-door banking. We accomplish this through gathering, analyzing, and interpreting numerous data points to bring forward a level of clarity, comfort, and sophistication that has been previously unavailable. With respect to the committee's time, in closing, I would like to say that we at Nationwide Compliance Specialists look forward to helping California tackle this complex issue. We believe that our approach of aligning the interests in which no group benefits at the expense of another will bring forward the cannabis industry out of the current shadowy don't ask, don't tell banking scenario to one in which it is open, transparent, and safer. We believe that this will contribute to a safer and more prosperous communities throughout the state.
Thank you. Any more public comment? Seeing none, we're going to end this hearing today. I want to thank all the speakers and panelists. I also would like to open this up at this point. If anyone has any follow-up questions, concerns, or thoughts, you can reach our committee staffers or myself, and we'll look forward to having a continued discussion on this. Thank you so much.